Yesterday, the attorney representing 7 same-sex couples challenging North Dakota's definition of marriage has asked the judge to bypass a trial and issue a ruling. The obvious question is, so what could this mean for North Dakota's constitutional amendment that bans same-sex marriage? So with us tonight to answer that question and more, Kellie Fiedorek. She serves as litigation counsel for the Alliance Defending Freedom organization. Kellie, thanks so much for joining us.
Thanks for having me on.
Now, obviously, let's go down some hypothetical trails here. We don't know if this is going to get granted or not, but assuming that they say, okay, we're going to just make a decision here via the judge, I want to get your thoughts on how this could impact what's happening here with North Dakota's constitutional amendment in the context of what just happened. I think it was today or yesterday in Colorado. A U.S. district judge said, hey, you know what? The ban on same-sex marriage is no longer good. It happened in Wisconsin, Utah. Correct me if I'm wrong, but I think it's like the 14th or 15th federal judge to come down and say, no, you've got to obviously recognize same-sex marriage. Where are we going here in North Dakota?
Well, you're right. There's been an increasing pattern across the United States with judges, these unelected judges, striking down the will of the people. And it's truly a tragedy for the democratic process. And in North Dakota in 2004, 73% of the people went to the ballot box to define marriage as one man and one woman because they saw that as something good for their state, and rightly so. And yet we're seeing these judges across the country come in and just literally wipe away the decision that rightfully belongs to the people of every state.
Well, let me go in a little bit different direction, because you study constitutional law. We live in a republic, so there's times where obviously it's not just the majority rules. And so when you look at the context of where they're making these decisions, I think a lot of it's being made from the 14th Amendment. You've obviously got, the due process clause, you've got the equal protection clause. So let's talk about first the equal protection piece. With your constitutional background, is that a place where, these judges have got the right idea, saying, look, these people deserve equal protection based on the 14th Amendment?
Well, the U.S. Supreme Court has been very clear in its precedent that marriage policy belongs to the state. It belongs to the people and their elected representatives. And their latest decision last summer in the U.S. v. Windsor case, Justice Kennedy made very, very clear that when it comes to marriage laws, it's important for the people. The people live marriage. They know marriage best. It's important for them, either through constitutional amendments or through the legislative process, for them to be able to define what marriage should be for their state. And that's where it really comes down to. It comes down to the people's right to define marriage. And in North Dakota, people saw that there were good, rational reasons that marriage should be between a man and a woman, that kids do need a mom and a dad, and it's not their place to intentionally deny a child a mom and dad in any situation.
So let's go then to, when you say there's rational reasons, let's talk about those specifically. What are the rational reasons that you say, hey, look, this is why marriage between a man and a woman is rightly defined, versus saying, you know what, we've got the Declaration of Independence, talks about life, liberty, the pursuit of happiness. Again, if I go back to the 14th Amendment, back in the Loving versus Virginia decision, which obviously overturned states' ban on interracial marriage, they even said themselves that you've got the freedom to marry. It's an essential civil right. So you say what to that?
Well, the fundamental right to marry has always been a gendered right. It's been the right to marry a person of the opposite sex, and for good reason. And the reason is because society depends on the next generation, and it's marriage between a man and woman is rooted in that biological fact that kids come from a mom and dad, that kids do need to have. They have a right to know their mom and dad and where they came from. And we know that this is beneficial to human flourishing and to the flourishing of ultimately society as a whole. So the fundamental right to marry has traditionally been, it's a gendered institution.
So if gay marriage or gays have the opportunity to have all the same legal rights, maybe in a civil union, but you didn't define it as marriage, would you be okay with that?
Well, again, marriage is a unique institution that has existed across cultures. It's across diverse cultures, faiths, throughout history. It's a relationship that's unlike any other. And obviously, here in America, we're free to love whom we want to love. But when it comes to the unique relationship of marriage, this is something that it is indeed rational for the state to protect, to ensure wherever possible kids do grow up knowing both their mother and their father.
So let's say this attorney gets his desire, the judge comes out, does his ruling, and then rules, as many of these other U.S. district court judges have, that, hey, look, you as a state need to recognize same-sex marriage. Where does North Dakota go from there?
Well, in some ways, we're not really that worried about these federal judges' decisions. I mean, they're terrible in the sense that they are completely ignoring the will of the people. But ultimately, this decision is going back to the U.S. Supreme Court, and the Supreme Court will decide, likely next summer, whether or not the states do have the right to define marriage, or whether they're going to impose this new definition of marriage on all 50 states. So ultimately, it really is the Supreme Court who's going to decide this. And if they're consistent with their past rationale and analysis, I think that they will uphold states' rights to define marriage as the states and the people of those states see fit.
So do they get it wrong when they say that, hey, the freedom to marry is a civil right?
Well, the fundamental right, again, goes back to it's the ability to marry. But marriage, in every single case where they talk about that fundamental right, has been marriage between a man and woman. And there are a lot of other restrictions on marriage. You can't marry someone that you're related to. You can't marry a minor. There's other limits on the fundamental right. But the fundamental right has traditionally been gendered, and for good reason, because you need a mom and a dad to create the next generation. And again, it goes back down really to children and what is best for them. And it's best for them to be able to know their mom and dad, and no one should ever be in a place to intentionally deny a child that right to know where he or she came from.
So what would you say to a foster child that is in a foster home, probably is never going to find out who his or her biological parents are, but you've got a loving couple who both are homosexual, says, hey, we want to adopt this child?
Well, I think the picture, that's the larger story is that, anyone is capable of loving a child, and they're capable of loving that child very well. But no one can ever provide a mother's perspective or a father's perspective. Men and women are different, and they have complementary differences. And these are important to a child, to have both the love of a mother and the love of a father. That we can't say that men and women are the same and they're not going to love a child in the same way.
I want to give you 60 seconds on one other topic as well, the Hobby Lobby decision that came obviously to the Supreme Court. My question for you is this, because I've talked to a lot of people about this, and a lot of women say, you know what, why should a company's rights trump my own personal freedoms for the choices I want to make with my body?
Well, again, everyone in that situation everyone is free. It's not a question about access to certain kinds of drugs. It's about coercing a family-owned business to violate their sincerely held beliefs. And Justice Alito is very clear that there's a human person behind every single family business, and they should be able to be free to follow their conscience and not be forced to provide abortion-inducing drugs that would violate their belief that human life is sacred.
Kellie Fiedorek, thank you so much for being with us. Again, attorney with the Alliance Defending Freedom organization. We really appreciate your time. I'd love to have you back on in the future, okay?
That sounds great. Great to be with you.